The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. Thank you for joining us. Our webinar today, Drug and Alcohol Testing in the Workplace. My name is Linda Duffy, and I'm president of Ethos Human Capital Solutions. I work with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. I'm going to be serving two roles today because for those of you that are with us on a regular basis, you'll know that our usual moderator is Julie Dorr. Julie is our marketing guru, and unfortunately she had something come up at the last minute today and is unable to join us, but we will look forward to her joining us again next month. Our presentation today will last approximately 40 minutes, and the remaining time will be spent answering your questions. If during the presentation you have any questions, feel free to type them in the designated section to the right in that panel that you see there, and we'll do our best to answer them at the end of the webinar. I will be able to run a report that tells me who asked what questions, so if for some reason we don't get to your question today, we can follow up with you, or feel free to give me or Marla a call or shoot us an email with your question so we can make sure you get it answered. Earlier this morning, we emailed you a link to a copy of our presentation so you can reference it during our webinar. If you did not get that, please go back to your email. It would have come from me at Constant Contact. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright and that this entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with legal counsel to address your specific situation. Speaking of legal counsel, let me also introduce my co-presenter, attorney Marla Merhab Robinson. Marla is with the law firm Merhab Robinson, Jackson & Clarkson, where she is a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. Marla's firm also handles business litigation and estate planning matters. And I'm going to turn it over to Marla to get started today. Go ahead, Marla.
Thank you so much, Linda, and I want to welcome everyone. Before we start our webinars, we always get a report of who's attending. So for those repeat attendees, thank you so much for continuing to join us every month. And for the new attendees, welcome, and we hope you will continue to join us throughout the year as we continue our webinars. So our agenda today, we're going to discuss the legal issues surrounding drug and alcohol testing, both the federal and state laws that apply, and the different types of circumstances when testing might happen: pre-employment testing, random testing, safety-sensitive positions, post-accident or incident testing, reasonable suspicion testing, and even off-duty testing. We will also discuss testing logistics, practice pointers, and policy considerations that hopefully will give you some takeaways today. And then, of course, we hope to have time for Q&A, but we always point out if we don't, because we do have quite a bit of material today, please feel free to email either Linda or myself, and we will get back to you with a response as soon as possible. So how are legal issues raised in the context of drug testing? Well, they're raised by rights that are created through the state and federal laws. And we'll go through those laws, as we said on the agenda, and you'll see that testing comes with some risk. So when deciding whether or not to test, you should assess whether it's worth the risk. Is the benefit of what's going to come out of the test worth the risk of testing? So the first right we're going to discuss is the California constitutional right to privacy. Our state's constitution says that all people have an inalienable right to privacy. In addition, unlike the federal constitution, California's constitution protects individuals from access by private parties, such as employers. The right is implicated, meaning it gives rise to whether the right was violated by drug testing. But that doesn't always mean that drug testing is illegal. We just need to know, does it affect or violate this right to privacy? The privacy right is not absolute, and the courts have not required a compelling justification for every action that has some impact on the right. Rather, when the challenged conduct does not substantially burden the right, the question is whether the conduct is reasonable. So the courts look at whether it's reasonable on a case-by-case basis, balancing the employer's reasons for testing against the intrusion on the employee or applicant, including how that intrusion occurs. Another law that gives rise to rights is the Federal Free Workplace Act, and this really mandates that some employers, those with government contracts of 100,000 or more, provide testing. California law covers essentially any employers providing goods or services to a state agency. So there's also a California version, federal version, and a California version of the Drug-Free Workplace Act. And then, of course, we have the great state of the city and county of San Francisco, which always has its own laws that we need to look at, which requires all employers to adopt a drug-free workplace program. Covered employers under these acts must publish a policy statement and establish a drug-free awareness program and notify employees of that policy. They must notify the contracting agencies if covered employees are convicted and impose penalties or rehabilitation. Further, they must make an ongoing good faith effort to be drug-free. Another statute in California, FEHA, Fair Employment and Housing Act, lists certain rights of employees to be free from discrimination. This can give rise to disability discrimination and disability discrimination claims. So under the FEHA, employers with 5 or more employees are prohibited from discrimination based on mental disabilities, physical disabilities, medical conditions, and others as specified in FEHA. Narcotics addictions are not protected physical disabilities. The federal Americans with Disabilities Act does not protect individuals who currently use drugs, and neither does FEHA. However, both laws do protect persons who are former abusers of alcohol or illegal drugs and who have been successfully rehabilitated, either through supervised rehabilitation programs or through their own programs, and can show that they no longer use drugs. However, because of FEHA's protections, employers may face disability discrimination claims if applicants or employees are taking medications for a disability, and that medication shows on a test, that applicant or employee is protected because the disability may be protected. Prescribed medications that turned up on drug tests and some drugs that might otherwise be illegal or legitimately prescribed for certain conditions might also be protected. An employer who singles out certain groups of employees, for example, by race, age, or gender, the other protections under FEHA for drug testing alone, could face a discrimination claim there. So there's potential rise of claims. The next slide, medical marijuana, is I get this question all the time because employees who are tested and test positive for marijuana will then show the employer, look, I have my medical marijuana card. And as you know, if you have your medical marijuana card, it makes the use legal in California, but it's still illegal under federal law. We have a California case right on point that says the employer does not have to accept marijuana use or positive testing even if the employee has the card. So if you have an employee who says, well, I have the card, you're still allowed to discipline up to and including terminations, and you may have a policy prohibiting the use, sale, or possession of marijuana while in company facility or on company property or while performing company business. You may still discipline or terminate for a violation of that policy, even though the employee may have the medical marijuana card. Drug or alcohol rehabilitation. If the employer has 25 or more employees, you must reasonably accommodate any employee who volunteers to enter an alcohol or drug rehabilitation program, provided the reasonable accommodation does not impose an undue hardship on the employer. This is under California Labor Code Section 1025, and these other sections cited here are also the California Labor Code. What's difficult here is there is no definition in the Labor Code, and we have no case law defining what that reasonable accommodation is. So it must be looked at on a case-by-case basis, and so you should seek the assistance of your attorney when determining that. And your attorney most likely won't be able to tell you, yes, this is definitely a reasonable accommodation, or it's not. They'll just give you an opinion on what they believe a judge or jury might find. Because, again, we have no clear-cut definitions. Employers are not required to provide time off with pay, however, we do have that in the Labor Code Section 1027, except that an employee may use sick leave to which the employee is entitled for the purpose of entering and participating in the alcohol or drug rehabilitation program. The employer must also make efforts to safeguard the privacy of an employee as to the fact that he or she is enrolled in such a program, keeping that information confidential. So no one should be allowed to have that information or see that information in the personnel file that doesn't have a right to see it, or excuse me, a need to see it. An alcoholic, a current alcoholic, is a person with a disability and is protected by the ADA, as well as an alcoholic who has been rehabilitated. And their protection is if they're, again, they're qualified to perform the essential functions of the job, no different than other ADA claims. As an employer, you may be required to provide an accommodation to the alcoholic, again, if they can show that they've either been rehabilitated or need rehabilitation. Change slides. I'm sorry, my screen is not up, so if I'm missing the slide, I apologize. So pre-employment drug testing. California law allows an employer to require a suspicionless drug test as a condition of employment, or pre-employment drug testing, after a job offer is tendered, but before the employee goes on the payroll. So a bona fide offer of employment must first be extended. Once the employer has made the offer of employment, a medical exam or a drug test may be requested. But seeking the exam prior to such an offer violates FEHA. The reason for that is because the exam, the drug testing is considered the same as a medical exam. It may bring out information that gives rise to the employer finding out that the employee or applicant, has a disability. And that, of course, is protected under FEHA. So that's the reason the bona fide offer has to be made. So if you are going to have conditions in your offer of passing maybe a personality test or other medical examination on lifting, you should have all of those tests done before you have the drug test done. Neither the ADA or FEHA protect individuals who are currently using drugs. So if there's current drug use, with the exception of the California statute that says you must reasonably accommodate if any request to assist them, the ADA and the FEHA do not protect them. But they do protect former abusers of both alcohol or illegal drugs. And I would add to that legal drugs as well, because legal drugs, maybe prescription might be considered legal, but once you use it illegally, it becomes an illegal drug. And those who have been successfully rehabilitated and who no longer use any of those. So things to consider with pre-employment drug testing. First thing to consider is potential claims. If you don't care about the results, don't test. I once had an employer who tested for all illegal drugs and called me and said, I have a prospective employee salesperson who tested positive for marijuana, and I really, really want to hire this person. He's exemplary in the industry. I kind of stole him away type of thing. Really want to hire him. And I asked the employer, if you don't care if people test positive for marijuana, why are you testing for that? Because you don't have to. You can direct what is tested and what is not tested. And so be particularly aware of that. Lynn, I'm sure, will be talking to that when she's talking about policy considerations. But if this is just some potential claims. If an applicant is turned down because of the positive drug test, and then the applicant's medication was legally prescribed for disability, there could be potential liability or a claim there. If the company singles out certain groups, we spoke about this before, any of the protected classes, race, disability, age, for drug testing, it could face a discrimination claim under FEHA. And it may be fine, though, to single out certain job classifications for testing. So, for example, if you have a manufacturing facility, you may be testing everyone in safety-sensitive positions in the plant, but not testing the office workers. But you should apply that uniformly to the specific classifications. Applicants' privacy, again, the very first right we spoke about, may be violated in the way the test is conducted. You have to use a licensed lab. There's different types of testing that's allowed, where and how the testing is conducted. If someone has to disrobe in front of someone else may create a problem and potential claims and liability. Another is defamation. And an example of that is publicizing that the employee tested positive. Again, this information should be kept confidential. There's a couple sample cases on pre-employment drug testing that are still good law today and cited very often. The Wilkinson versus Time Mirror Court case was about a private publishing company, and the court held that it did not violate the prospective employee's constitutional right of privacy when it conditioned its offer of employment. Again, this is after the offer of employment, on the employee's consent to urine analysis as testing. So this goes to the question of what type is okay. Urine analysis was okay for alcohol and other drugs. the prospective employees were told of the program, so they could always turn around and say no. That's something the courts always look at, is the employees can turn around and say, you know, I don't want to take this test. And it was done in a manner where the intrusiveness of collection was not unreasonable and not violative of the right to privacy. The other seminal case in this area is Loader versus City of Glendale, and you can see these are not terribly old cases in the eyes of law. That this was suspicionless urinalysis drug testing of all applicants, again, who were offered positions, who already had their position offered, and the court held it was constitutionally reasonable because the city had a legitimate interest in whether the prospective employees were abusing drugs or alcohol in light of documented problems before by city employees. So again, the court is looking at the interest of the business to have a drug-free workplace and balancing that against the employee's right to privacy. Excuse me, I took a sip of water. Looking at that balancing test and then also looking at the procedures to make sure the procedures are done correctly. In current employees, routine or random drug testing. So testing rejected in non-safety contexts. The courts have been holding that an employer may not require employees to submit to random drug testings except under certain narrowly defined circumstances, such as when the employee is in a safety or security sensitive position. There's a direct nexus, which is a connection. Nexus means connection between the employee's duties and the nature of the feared harm. An example of that would be a railroad driver, which is a case cited there. But you can imagine someone who is charged with the public safety and health, like taxi drivers, railroad drivers, pilots. It's very important that safety be maintained. But in a non-safety context, random drug testing has been disallowed. And testing is permitted in safety cases. This is an additional sample case as part of an overall program to promote safe conditions. We've put a couple case names there, but not the sites for those of you who are legal geeks like me. One of them is an offshore drilling platform's right to privacy was not violated by the employer's random urine analysis requirement because offshore platform work is hazardous work. It's a very hazardous environment, and it gave the employer a compelling interest. So again, it's that balancing of interest between the employer's right or need for a drug-free workplace and the employee's right to privacy. Well, this was a compelling interest because the employer had a very hazardous work environment already, and the employer needed it to be safe. The DOE and the DOE also require certain employees to be tested, and if granted a contract by those agencies, sometimes employers are required to test. A great example of this is nuclear power plants. You can imagine this is another hazardous work environment that needs to have this, and that falls under the Drug-Free Workplace Act. Testing pursuant to last chance agreements. Testing often doesn't stop the process. It starts the process. Now that we've tested positive, an employee has tested positive, what do? I gave you the example of my one client. So the applicant tested positive, and that didn't stop because the employer still wanted to hire that applicant. So what the employer in that case did was went ahead and hired that applicant and immediately changed its policy and stopped testing for marijuana. Sometimes you have employees in safety-sensitive positions who test positive that are already current employees, and yet you don't want to terminate. You just want to discipline. So employers will often enter into last chance agreements. In lieu of terminating them, an employee who tests positive for illegal, or I will again say legal, prescription drugs used in a context that could still be impacting safety, we will enter into a last chance agreement. These types of agreements spell out the terms of continued employment, one of which could be random testing. Our slide says one of which, most often that's exactly what it is continued random testing. Sometimes it's even a rehabilitation program and proof that the employee has completed that program. It depends on the offense. It depends on what the test was positive for and in what context the test was made. So with that, I will turn it over to Linda.
Well, thank you very much, Marla. That was great. And I'm going to pick up where Marla left off, talking about some of the other conditions on which you might be able to drug test employees at work. And the first one I'm going to talk about is safety-related random drug testing. Now, I don't have a lot of companies or clients that are doing random drug testing, and it is one of the more riskier tests. Marla talked about the two that are probably the safest out of all the testing, the pre-employment testing and then sort of the last chance agreement. Someone wants to keep their job, but they've been in violation of company policy. At that point, you can get them to enter into an agreement. But to do random drug testing on employees at work, you're essentially balancing the employee's right to privacy, as Marla first talked about, under the California Constitution, with the employer's safety-related reasons for wanting to drug test employees. And so, really it comes down to, which is the larger, which is the better interest, the employee's privacy interest or the employer's safety-related interest. And if you're trying to balance those two out and determining whether or not the employee has an expectation of privacy or the employer has a legitimate reason for wanting to drug test people. So in all the case law that's out there, it comes down to a couple things. The courts looked at, under what circumstances is the safety-related position so important that if they just made a single slip-up, it could have sort of irreversible or disastrous consequences. So some examples might be you have someone who carries a gun. If they're under the influence, they may make a mistake and kill somebody, obviously. A train engineer, if they're under the influence of something, and run the train off track, has disastrous consequences. Another example that people might not think about automatically would be sewage and wastewater treatment plants. Courts have found that, those plants are so heavily regulated by both federal law and states because of the harm that a sewage spill can cause. And depending on the position, plant employees may regularly use hazardous chemicals and equipment that are very dangerous and may have responsibility for being first responders to an emergency situation. And so for those reasons, they said, hey, if you want to randomly test, certain employees at a wastewater treatment plant, then that's fine. Now, not everybody, though, in safety situations may be in safety-sensitive jobs to give rise to the level of drug testing on a random basis, and that has to do with the level of supervision or scrutiny they receive. So in other examples, there was a transit authority where elevator mechanics were randomly tested, and the court says, that's fine, not just because the elevator might fall, but because the mechanics had very little supervision on the job. And so if they were impaired in any way, it might go unnoticed. However, in that same transit authority, other people like carpenters, masons, plumbers, and iron workers were not considered to be in safety-sensitive positions because they either worked in pairs or they were subject to direct supervision. So you sort of have two things to consider. What are the consequences if something goes terribly wrong? And then also, what's the level of scrutiny or supervision they receive? Would somebody notice an impairment ahead of time to prevent those disastrous consequences? So consider both of those things before you start randomly drug testing under safety-sensitive rules. Now, I get this phone call a lot, which is, well, my office manager has to drive to Staples to pick up office supplies. Can we drug test her? And my answer is generally no, I would not do that. And that's because really driving could be considered a safety-sensitive activity. Certainly when it's a primary duty, like if you're a bus driver, a train engineer, ambulance driver, or sanitation truck driver, as Marla mentioned, taxi cab drivers. When your essential primary job duty is driving, then you can probably go ahead and drug test those people on a random basis because that would be considered a safety-sensitive activity. But if somebody's just driving on an occasional basis to drop something off, it's, we can't wait to FedEx it or put it in the mail, it has to be picked up, or they're just going to Staples once in a while, then that's not going to be considered a safety-sensitive driving position. Okay, so if it's something when they're doing it on a regular basis and it's really the essential job function, then you can probably test them. But if it's just an occasional thing, then I would not put that into a safety-sensitive category. Another category, though, where you can do testing is post-accident, or what some companies might call unsafe practice testing. And I'll just say proceed cautiously here. I have a lot of clients, and I have had this policy in the past where if somebody's involved in an accident of some kind, if somebody becomes injured and they go to the clinic, they automatically drug tested. So I would say you don't want to have a blanket policy where employees who are involved in an accident are tested. I know a lot of you do, and if you do have it, you want to make sure you're not just singling out the injured party. Because, for example, if I'm driving a forklift through the warehouse and I run Marla over, I might be fine. You know, I might be under the influence, but I might not be physically injured. But Marla's going to go to the clinic, right, or to the hospital or wherever for treatment. So it wouldn't make sense to drug test only Marla under those circumstances. And unfortunately, I see a lot of policies written that way, where it's the injured party who's going to be tested, and that could get you sued pretty easily, I think. So if you are going to have that policy, then make sure you are including anybody who is involved in that incident, not just the injured party. Having said that, though, some case law has suggested that you need to have a higher standard than that and not just have it be anyone involved in an accident or an unsafe practice. Rather, they're saying there has to be a higher threshold than that. And so the two things that they point out is having some level of property damage of a significant amount. And they're saying $1,000 is probably too little. So I know I wrote a policy last year for a company, a client of mine that does hazardous material remediation. And so we set that number at $2,500. I have to be honest, it's a fairly random number. I mean, I just looked at case law and said, okay, $1,000 is too little. What would make more sense? And so we came up with $2,500. So set a property damage number, and then also an injury demanding medical treatment away from the scene of the accident or requiring immediate medical attention. So it's a twofold process of looking at it. And so consider both of those issues as you make the decision whether or not to test post-accident. Now, we talked about this just briefly as Marla was going through some of her slides about reasonable suspicion testing. So unfortunately, the courts provide a little guidance about what that definition is. So what is reasonable suspicion? Well, don't really know. It's sort of in the eye of the beholder. I'll know it when I see it, which doesn't leave us with a lot of direction about what that means. What you basically want to do is rely on some objective criteria that's been developed over time by medical professionals and regulators, and I'm going to go through some of those things on the next slide. When you don't have a reasonable suspicion of drug use, then the employee's privacy rights are probably going to outweigh the employer's business interests. So you want to make sure, again, that you're doing that fine balancing act before you just move forward and decide you want to test people. So when you do take a look at the reasonable suspicion testing, this is generally some of the rules the courts have come up with. They're saying, okay, there's been case law that says under these circumstances, the courts have found drug testing to be constitutional. So one would be direct observation of drug use or possession. You see somebody using drugs, you see somebody with drugs in their possession, you're probably fine going ahead and drug testing them. Another one would be direct observation of physical symptoms being under the influence. Okay, so their motor functions are impaired, their speech is slurred, things like that. Now, I will caution you there, you need to make sure that you're training your supervisors on how to recognize those symptoms of being under the influence. If someone comes into work today and their eyes are bloodshot, is it because of drug or alcohol use? Is it because they were crying? Is it because of lack of sleep? You need to make sure that you know exactly what you're observing and that it's a specific physical symptom of being under the influence and not something else. And also, if you're going to use direct observation, make sure that you have a second person verify. So don't just have one supervisor go look and say, hey, I smelled alcohol in this person's breath, without having a second person go and double check to make sure that they also smell the alcohol in the breath. A pattern of abnormal conduct or erratic behavior might give rise to drug testing somebody, and then information that's provided by a reliable and credible source or that can be independently corroborated. And again, be careful, because there's a definition there for reliable and credible source. Who's to say what's reliable, what's credible? But if somebody that comes forward and you believe that they are reliable and credible, you might be able to drug test based on their information. And then also, if you have newly discovered evidence that the employee tampered with a previous drug test, you might be okay having them go back and retest. Sorry about that. So on the last one we're going to talk about is off-duty drug testing. So I have not had any client with this. I don't believe Marla has either. There is a possibility of off-duty drug testing, meaning when people are off work, calling them up and saying, hey, report for a drug test. That's going to be very narrow exceptions to general drug testing policies. So, for example, at least what we hallucinate might be somebody that falls in that category. You have a trained engineer. They're not working today, but you drew their name in your random drug testing lottery, and so you call them up and you say, hey, we need you to go down and pee in a cup, or maybe police officers or somebody like that. And it's probably, I'm just going to guess, also part of a bargaining agreement. So we don't have any clients, but there is a possibility of off-duty drug testing, so just be aware of that. Send them any place. Yes, they can do the drug test, but there are certain rules about occupational drug testing that you want your clinic to be familiar with. I know in the past, in Orange County anyway, we've always used U.S. HealthWorks because they're sort of all over the place, and they also do workers' comp treatment, and so it made sense just to have our employees go to that clinic, but there are plenty of clinics out there. But I would just urge you to make sure that they are familiar with the rules around occupational drug testing. The company's going to pay for testing costs. Marla, after we're done here, you might want to address whether under a last chance agreement they could require the employee to pay for the test. But generally, the company is going to pay for the test, and employees are going to be tested on the clock, meaning you're going to pay for their time when they go take the test. Now, transportation to and from the clinic should be provided, and the one exception of that would be for pre-employment, testing. If you can have the applicant, I should say, can go ahead and drive themselves to the clinic. Hopefully nobody does this, but certainly do not want to go to an employee that you believe is under the influence of something and say, drive yourself to the clinic. That wouldn't make any sense. So put them in a cab, have a coworker drive them, whatever you want to do, but don't let the employee you believe to be under the influence drive themselves to the clinic. A few more practice pointers before we talk about what you should include in your policy. So of course, again, you're balancing the company's needs against the employee's privacy rights. So you want to think through, for each of the different positions. As Marla pointed out, you can have different rules. Just because you want to test one employee doesn't mean you have to test all of them. You just should make sure that you're testing people that are similarly situated. So if you have a manufacturing company and you want to test your machinist, because they have a greater potential for injury than your accounts payable clerk. Employers can generally conduct pre-employment, post-offer testing. Again, as Marla said, want to make sure that the offer has been extended already, although you can make it contingent upon passing the drug test. And then make sure that you do whatever you can to balance, to reduce the employee's expectation of privacy. And I would even suggest that you include this in ads that you place for openings, for example, put on there that that employees are drug tested under what circumstances. You can just have a brief sentence. But people will self-select out if they're using drugs. Not always, but at least a large percentage, I believe, will self-select out, which will not waste your time then in actually considering them as candidates. So put it in ads, put on the application form. If people come into your lobby to fill out applications, put a little sign there. Do whatever you want to do. Make sure it's in your handbook, of course, if you're going to test current employees. But make sure people understand that your company is a drug-free workplace zone and that you do whatever you can to limit that. You can demonstrate a commitment to a drug-free workplace by having policies and procedures in place and also discouraging and disapproving of illegal drug use. Make sure, as we mentioned, you apply the anti-drug policies fairly and consistently, and make sure that you treat everybody similarly that is similarly situated. And then train managers adequately, not just on what constitutes suspicion of drug use, but also just procedures in conducting effective drug tests. Make sure that they know what to do. And I would say pay particular attention to your second and third shift employees if you have those as well. Because a lot of here are some things that I know I include when I write a policy. The first one is to have an overall workplace drug and alcohol policy statement. You can go out and Google, drug and alcohol policy statements. You can look up Drug-Free Workplace Act. You can get a pretty comprehensive policy statement pretty easily. You certainly want to include a prohibition against the use and possession of drugs or alcohol. Overall, just make sure that people know that they're not allowed to have them on site. They're not allowed to be under the influence, even if they're not on site, if they're doing company business away from your office as well. So your outside salespeople, under what circumstances, basically, are you going to prohibit their use? I would include a statement regarding the use of prescription and over-the-counter drugs. Like Marla said, legal drugs used, outside of how they are prescribed become illegal drugs. So the other thing to consider is they could have a prescription for that drug, not just medical marijuana, but a prescription for some sort of drug. But there's plenty of drugs out there, and on the bottle it says, don't operate heavy equipment or machinery, right? So you want to make sure that employees know that if they are under any sort of drug, they need to bring it to your attention if it could somehow impair their ability to do their job. I would include in California anyway, or in any state where medical marijuana is legal, I would include a prohibition against medical marijuana statement just so people do understand that it's still illegal under federal law. Now, as Marla pointed out, you have the right to decide what to test for. And Marla knows this story. When I was working at a heavy manufacturing company early in my career, we decided very early on that we were going to drug test, but we also said, you know what, if someone tests, quote unquote, only for pot, we're just going to counsel them. We're going to say, hey, you can't be under the influence because pot will stay in your system 60 days, 90 days, and still test positive. So our feeling was, hey, we're not going to make a judgment about anybody who smokes weed on a Saturday night as opposed to drinking, a bottle of wine. Unfortunately, what happened in that circumstance was we had a machinist show up to work clearly, in our opinion, clearly under the influence of being, of having smoked pot. And when I approached him about it after the supervisor brought it to my attention, he said, well, you knew I smoked pot. We talked about it when you hired me. So he, of course, denied being directly under the influence, but he also knew if we sent him to the clinic right then, he would test pot, test positive, and we were sort of in a bind, and that was the day our policy changed. So be careful as you think this through, what you're going to test for, and if you want to make exception, just think through the consequences and remember that story. A couple other things that people may not consider. These are requirements under drug-free workplace laws, but also just common sense. I would have a statement in the policy that if somebody comes to, if somebody has knowledge that somebody else in the company is using or selling or possessing drugs or alcohol, that they need to bring that to your attention and inform the company. And then also similarly, if somebody is convicted of some sort of drug-related offense, that they need to notify the company within 5 days. Include a statement about testing. Under what circumstances are you going to test? Again, so what are you going to test? But under what circumstances are you going to do only pre-employment? Are you going to do random drug testing, safety-sensitive drug testing? What I would say is this: leave the possibility open for as many types of drug testing that you can, even if you have no intention of doing it. Sort of leave open that possibility and put it in there. You don't need to necessarily enforce it, but you have it there if you need to in the long run. Include some logistics. You don't have to be super specific to say we're going to use clinic ABC, but you could just say, that you're going to pay for the test, you're going to pay for the company's time, companies will be provided, or employees will be provided transportation, things like that. Really important that you include a statement regarding consequences for refusing to submit to the test and what happens, and I'm sure we'll have some questions about that for Marla to answer. A statement about rehabilitation, and then finally disciplinary action. What happens if somebody flunks a test? What happens if someone refuses to submit to the test? And with that, we are going to take some questions and answers, and I cannot find my little thing there. There we go. So hopefully I'll take a look here. If you have questions, just go ahead and type them into the little question box that's there on the right, or put them into the chat box, one of the other. Right now, I don't see any questions typed in there. So Marla, can we go back while people are entering their questions? And can you talk a little bit about what employers should have in terms of a policy for employees who refuse to submit? So I come into an employee and I say, you know what, I think you're under the influence. I have a second manager that verifies it. I'm going to send you to the clinic. The employee says, nope, not going to do it.
Well, it depends on the employer. And those of you who've joined us before know, you hear me say this all the time. Every employer has a different culture in their offices, and it depends. If you have an employer, for example, I represent a lot of private schools. If you have an employee who refuses to drug test on a reasonable suspicion, they're going to let them go right away. If you have an employer in the technology field that has a lot of very young employees, they may not. They may say, okay, well, we're going to wait, and if there's a second instance, we're going to write you up, and we're just going to discipline. So it depends on each employer, but certainly to Linda's most important point is all of these policy considerations, and what a great job, Linda. All of these things should be looked at for each individual employer every time for what works for that employer. I even have some employers that if the employee tests positive for drugs, won't terminate right away. They want to talk to the employee about rehabilitation. They want to talk to the employee about the circumstances of the drug use, and they may even give another chance. But of course, others that have employees in safety-sensitive positions, they're going to terminate immediately. So it depends on the culture of that particular employer, why you're testing in the first place. Certainly if you're testing for safety, you're more likely to terminate immediately if someone refuses to test or test positive than others. But that goes to the point of making sure that your policy is correctly written. You can't just take one out of a form handbook and slap it into your company or pull Coca-Cola's or Hewlett-Packard's because it won't work.
Great. Okay, waiting to see if we have any other questions show up. If not, we're just going to go ahead and end the webinar early. While I'm waiting for questions, I will go ahead and just tell you about our next webinar, which has traditionally been our most popular webinar, interestingly to us. It is on November 13th, and it's going to be on disciplinary action and termination. We do have a question from Jerry about will a copy of this presentation be available. And yes, Jerry, it was sent out to everybody. If for some reason you did not receive that email, go ahead and send me an email and I'll send it to you. This will be included, obviously, on a slide, so you can click on this link right here, and then you'll be able to go and register for the November 13th. I think last time we did this, we had over 100 people attend, so it's been very popular and with a lot of questions. All right, Jane asks, after injury in the workplace where there is no property damage but an employee is injured, would workers' comp require a drug test? I'm personally not aware, Jane, of any, unless you have a weird workers' comp policy, I'm not aware of any requirement from your workers' comp carrier to drug test. Marla, have you ever heard of that before?
I have not heard of a requirement. I do know that they like it. But again, the exposure is to the employer, and unless you have those other elements that Linda talked about, just because the courts have made it very clear, just because there's an accident does not mean there's drugs involved. Accidents happen all the time. And so unless there's something more, I would not test. Now, if there's something more, then I would. And of course, there are some federal regs that are a little bit different on that. But for most of us, unless you have those other elements Linda discussed, I wouldn't necessarily do it.
Right, and we have a follow-up question to that one. But Jane, I'll also tell you, since I know a little bit more about your situation at your company, Because you guys have your workers' comp through a PEO, I would go back and talk to BBSI and ask them what their requirement is and make sure that they don't impose some sort of requirement outside, since there's sort of a joint employer relationship there. Okay,
Yeah.
Heather has a follow-up question. Can you talk a little bit more about the risk associated with post-accident testing beyond the privacy issues, et cetera? In particular, I understand that OSHA could see a termination or disciplinary action based on a positive test as retaliatory. Yeah, definitely. Marla, you want to talk about 132A claims?
Well, 132A claims are based on, just as it says, Labor Code Section 132A, and that's taking any action against an employee who files any employment action against an employee because they filed a workers' comp claim. So if you have an employee who's hurt at work and they file a workers' comp claim, or even if they're about to file a claim, and you take action of suspension, discipline, termination, any of those, demotion, change rate of pay, change position, anything, any change in their employment position, you run the risk 99% chance that they're going to file a petition for 132A under the Labor Code section. It's basically the same as a wrongful termination, although it doesn't have to be a termination. But it's heard in the workers' comp arena. That doesn't mean you shouldn't do it. If you have reasonable suspicion testing, you test, and the person tests positive for methamphetamine, it's the same person who was driving the forklift and dropped a pallet of boxes on them, doesn't mean you shouldn't terminate them because you're afraid of that 132A action. You just have to then respond to that. 132A actions are frightening to employers because they're not covered by your workers' comp insurance, so you have to obtain your own attorney that's not appointed and paid for by your workers' comp carrier. We do them. We're very successful with them in responding by denying where appropriate and then requiring the carrier to settle them at the same time they settle the claim. So you might have a very legitimate claim of getting hurt at work, but not a legitimate 132A claim.
Yeah, and Heather, I would just add to that to say that's why if you go back to the slide that I had on post-accident unsafe practices testing, that's why you're not going to single out the person who is injured per se. Your policy needs to be a little bit larger, and that if you're going to have a policy, at the very minimum you want to test everybody involved in the accident, so you try to avoid that, because I think if you're only testing people who are injured at work, then it could be perceived as retaliatory for coming forward. But if you're saying, look, anytime there's an incident, right, and that somebody's injured, we test everybody involved, you know, the person driving the forklift, the person injured, whatever, then it reduces that potential risk. Again, there's been case law that suggests that even that seems to be too narrow, and that you need to have a higher threshold in terms of the level of medical attention needed and the level of property damage. So just think about that and then take your best shot on that test. Guadalupe asks, can you have the drug testing policy in the employee handbook but not enforce it at the time of hire in the case that you need to do a random drug test in the future? So Guadalupe, I'm not exactly sure what you mean about having the drug testing policy in the handbook and not enforcing it at the time of hire. So I'm not exactly sure what you mean, but let me take a shot. Marla can too, and if this doesn't address it, then we can take it offline, or you can type in a follow-up question. So one of the things I had mentioned is I would put in my handbook all sorts of potential drug testing scenarios. We're going to do safety-sensitive testing for people that we believe are on those type of jobs. We're going to do reasonable suspicion testing. We're going to do pre-employment testing. We're going to do random drug testing if, again, our company, you know, gives rise based on the work we do. Most of my clients don't do random drug testing. I think I have one that may do random drug testing, and again, that's a hazardous material remediation company. So they're working with asbestos. They're working with, you know, equipment, hazardous materials all day long. If someone screws up, then there's, you know, potential disastrous consequences. But in general, most of my clients don't do random drug testing. But all the other types of drug testing, you may choose that you want to do them, post-accident testing. So I would include them in the handbook. If you just, you know, if you right now say we're not going to do any of this testing, you can still include it in the handbook and just not do it. The flip side of this is I would not selectively enforce it. So at some point, if you decide you're going to do post-accident testing, for example, then do it across the board in all cases where it meets your threshold definition, whatever you've set. Don't just say, well, we don't like this one person, so we're going to, drug test him or her. Marla, anything you want to add to that?
No, I agree with everything you just said.
All right, great. Any last questions? And maybe I'll give you one more chance just to jump on here and type in any sort of questions if you have them. Of course, if you think of something after we end this presentation, feel free to go ahead and give me or Marla a call or just email us, and we'll go ahead and get back to you as quickly as possible. If that's it, then I'm just going to say on behalf of Marla and myself, I'd like to thank you all for joining us. Please feel free to contact me or Marla with any questions you may have. Our contact information is included in the first couple of slides. As I mentioned, on November 13th, we're going to be talking about disciplinary action and termination, so we hope that you will join us for that. That will be our last presentation for the year. We're going to take December off, and then we will be back next. Oops, sorry, we did not update this slide. So I just told you to be November 13th, but there's our contact information. And then our next presentation after that, the date has not been set, but it'll be in January. We'll be talking about new laws for the new year, which has also always been a very popular webinar. As most people know, there's been some new laws already decided that will go into effect next year, probably most importantly the sick pay requirement that goes into effect next July. So I'm sure we'll be spending some time talking about that in addition to anything else. We appreciate your time today and look forward to providing you with more useful information in the future. Have a great rest of the day, and again, thank you for joining us.
Thank you, everybody.